So we've been into this decision of Obergefell for about 10 years now. The 4-5 decision, the 4 dissenting decisions, they argued that the Supreme Court had exceeded its constitutional authority, it's undermined state sovereignty, and it disrupted the democratic process, the same process that we use to make decisions on wolf hunting in our states or marijuana. Those kinds of decisions, they're not defined in the Constitution. The federal government has no authority over those kinds of decisions. So while the justices, they didn't agree on every point in this dissension, they all agreed on one thing, that the Constitution did not guarantee a right to same-sex marriage, and that's what this case was about. What this resolution does is it rejects the Obergefell decision. It just says we don't recognize unconstitutional decisions by courts. We're calling for a reversal of the Supreme Court decision and asking them, a reversal, what that would look like is asking them to revisit the case. And it sounds like there's going to be some cases coming up, actually one from Idaho that might actually be that case. And then we're asking them to restore state authority. This is a state's rights. If the Supreme Court can start creating all kinds of new rights that they want to use to push down onto states, you can see this could end badly for Idaho.
This is not about state rights, actually. If you look very closely at this memorial, around lines 10 to 12 on page 2, it actually calls for the Supreme Court to declare that from coast to coast, essentially, that union is between a man and a woman. So this really is not about deferring it to state rights. It's about coming up with a new judicially declared mandate in the opposite direction and saying, oh, the Supreme Court is going to define marriage. This memorial just asked them to define it as the opposite of the way they've defined it now. So this is very much about judicial overreach and not about states' rights. But on states' rights, I guess I would ask, we're a country. We are a country. We are not just a collection of states. We have a constitution. We have a Bill of Rights. And we have certain uniform rights that everybody has access to from coast to coast. This is not a state-by-state thing. That's why we fought a civil war. What else are we going to call them? What about Loving versus Virginia? So should the Supreme Court overturn that too, so that states can put back in place bans on interracial marriage? Should they be able to put back in segregated lunch counters and segregated schools? I mean, not everything actually is in the domain. There are certain rights that cannot be crossed by states. This has been determined again and again by the blood of many Americans in the Civil War, and this is a core right that is a national one that is guaranteed by the Bill of Rights.
Thank you, Mr. Speaker. Before I get started on this memorial, I want to share a little bit about what this memorial is about. This memorial is about federalism and a state's rights or their sovereignty to make decisions for ourselves. It is about the state sovereignty that we have as individuals of this state. This is not a memorial about defining marriage. It's about who gets to define marriage. Do we want the state to make those decisions, or do we want to allow the Supreme Court to make those decisions? Everyone's entitled to their viewpoint on marriage, but what I'm asking for in this resolution is that these decisions need to be made in the state. So to give you a little background, in 2015, the Supreme Court handed down a 4-5 decision in Obergefell versus Hodges. And what they claimed was, they claimed to legalize same-sex marriage nationwide. And it confused marriage laws and constitutions across the country. Remember, this same Supreme Court used this same reasoning to make its decision for a right to privacy on Roe versus Wade. And that's how they justified abortion, which, as we know, was overturned 50 years later. I want to just share a few of the 4 dissenting voices as some of their concerns. Justice John Roberts criticized the court for acting as a legislature by trying to redefine the word marriage. He emphasized that the Constitution doesn't define marriage. That means it's a state issue. It is not something the Supreme Court should be doing. And he also argued that it was a clear example of judicial activism. Scalia warned that that going down this route would allow unelected judges to make decisions over the people in our states. And they criticized the majority for trying to create a new right that is not found in the Constitution. Clarence Thomas said liberty was misinterpreted and argued that the majority had misinterpreted the concept of liberty, and they defined this in the Due Process Clause. And Samuel Alito, the final dissenting voice, talked about traditional marriage as deeply rooted in culture and history, and he warned that the decision would stigmatize those who didn't believe that this court ruling, who did have a different view of marriage. And he brought up that this judicial overreach would cause conflict down the road in people that held a different belief of marriage than what the Supreme Court ruled. So their common concerns: federalism, taking authority away from the states, judicial activism, overstepping the role of judges, and then disenfranchising voters. We have laws on our books that we have decided as a state that citizens get to come and testify on. If we start turning over decisions that aren't the authority of the federal government to our judiciary, we lose debate, we lose conversations. There was a lot of lively conversation on this in committee, and all those decisions would be suppressed. So obviously the big issue here is this: the federal government does not have the authority to just create rights out of thin air. And just because you may agree with their decision and how they define marriage or as a right, I would ask you to substitute any other issue and ask yourself, do I want the federal government creating rights and for us, for Idahoans? So what if the federal government redefined property rights or nationalized water rights? What does that look like if they came up with some new fair use policy or came up with different ways to define property rights? That is not a decision for the judges. It is a decision for the states and how we define property rights, what we do with our water rights. We do not want to nationalize decisions like this. I guess an example for that is if they came up with a nationalized water, actually a new energy policy. If they came up with a new energy policy and just said, we believe dams are bad for the environment, so Idaho, you're going to have to follow this ruling and tear out your dams. We do not want that. We want to be having these conversations in our states. So the language is a lot of whereases, like most of these resolutions are. I'll just briefly go through them. On line 6, we talk about the Supreme Court decision conflicts with the Constitution. Lines 10, liberty as defined by the government. Liberty as freedom from government, not as given by government. The redefinition of liberty that they've done. We talk about the vision of human rights. Page 1, line 21, undermining human dignity. And then lines 23, misuse of the Constitutional's due process clause. And that's where they came up with this new right to a marriage. A big concern, and this was of the dissenting votes and of it's in this resolution, is the threats to religious liberty. And I actually found a lot of examples of this that's happening throughout our country that's directly related to the Obergefell decision. Christians across the nation are being targeted. So there was the Kentucky County Clerk, Kim Davis, you may remember, who, after the Obergefell ruling, was told she had to sign a marriage license for a same-sex marriage. This was deeply against her religious beliefs. She asked for a religious exemption, and she was thrown in jail for six days. Now, this is being challenged, and actually, this case is going to be in a higher court come this week. I think it's this week. So they will be addressing this on this issue. Jack Phillips was the cake maker who felt compelled to not support a type of marriage he did not agree with. Lori Smith was given fines. She's lost her business license for a similar issue. There was Elaine Hugan, a photographer who had religious beliefs that were violated, and a person with flowers that wanted to not support something that was against their religious beliefs. And then a very important one that happened just 10 days ago. Oh, actually, wait, one more. The Catholic Charities of Philadelphia, with their adoption, they were removed from a roster because of their beliefs on marriage, their religious beliefs on marriage. So these are big issues, and these are state issues. This is it's snowballing effect across the country. So one example right here in Idaho, and actually about 10 days ago, this suit just got filed, and it is Idaho National Guard Major David Worley is being persecuted because of his beliefs about marriage and sexuality. And he lost his position in the Idaho National Guard, and now there's a current lawsuit against Brad Little, and I guess I can say that because it's the gentleman on the second floor, but that's what the lawsuit says. Major General Timothy Donnellan and Brigadier General James Packwood. And these are because these lawsuits are coming up because people have strongly held religious beliefs, and that is a right that's in our Constitution that's being violated. Trying to get it all out so there's no questions of what this does. Now, they can ignore this. They can ignore it, but they can also take note that we understand there has been an overreach in the decision-making for something they don't have the authority to do. Again, I really want to reiterate this. This is to restore federalism, calling for the issue of marriage laws to the states, not to the federal government. And I have a little bit more, but I think I'm going to end it there because I think my point's clear, and I know we have a lunch. And with that, I'll ask for your green light on this resolution.
Thank you, good lady. You've heard the motion. Further debate on the motion. Hearing the gentleman 25.
Yeah, Mr. Speaker, if the good lady would, well, I don't have a question actually.
Okay.
She's referred to this as a
The
resolution.
good lady would the good gentleman like to debate the
I'd
motion?
like to have the floor.
Gentleman has the floor to debate the motion.
This has been very difficult for me because I believe in 99% of what's written here. But the good lady referenced this as a resolution. This is not a resolution. This is like a letter to the Supreme Court. And there is a clause in this resolution that says, now therefore be it resolved by the members, yada, 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 that we reject the Obergefell decision. And I'm not sure we have that authority to do that in a letter. And is that going to sound like it's binding on us? Is that we've rejected some form of law? That maybe that's more appropriate in law or in a House resolution, but I'm struggling with that phrase that we have separation of powers, the executive power, legislative power, and judicial power. And I've never known us to have the authority to reject even an Idaho State Supreme Court decision, much less to reject a U.S. Supreme Court decision. I think that the U.S. Supreme Court went beyond their powers when they made this decision, but I'm having a difficult time with that. And I'm making these statements because I'm not 100% sure how I'm going to vote on this, but this is a troublesome phrase in there that we are rejecting the U.S. Supreme Court, which Idaho has adopted as the supreme law of the land, which says that we should obey their decisions. I really struggle with that, and I just had to make sure I said that before I voted. Thank you.
Thank you, Gentleman 25. Is further debate on the motion? Gentleman 16.
Thank you, Mr. Speaker, to debate the memorial.
Gentleman has the floor to debate the memorial.
Thank you, Mr. Speaker, and good body. Last week, the good gentleman from 22 made the comment that it costs us about $70,000 a day to operate in session, which is a lot of money. And I could not agree more that we need to be frugal and focus in terms of what we're doing here to make sure we're making Idahoans' lives better. However, this memorial does not do that. As the good gentleman from 25 pointed, this is just a letter. It has no force of law. The courts are going to toss it in the trash. It really accomplishes nothing. It's a waste of time and money.
I object.
Lady from 2, would you like to state your objection?
Sure. Just because someone doesn't think it's important or valuable doesn't mean other people might not think it is. So I just ask that he be respectful of me bringing it forward.
Thank you, lady. Good gentleman, proceed with caution.
Appreciate that, Mr. Speaker. Again, this is not a legal document. It's a memorial. It's a statement. And the cost that we're spending on this in terms of hours and debate could have been better used. Probably could have funded a couple troopers and maybe a few vehicles, maybe a roof on a small school. This is really, at the end of the day, nothing more than a grumpy letter, but with our names on it. The fiscal responsible thing to do is to stop it here and to stop it today, which is what the majority of Idahoans wants. If you look at the submissions of what the written testimony provided to the State Affairs Committee, of the initial 426 comments submitted, 424, 99% were against this. I think a better way to approach this, and I respect the good lady's perspective on this issue, is to just write a letter, have some folks co-sign it, and put a stamp on it and send it to the courts. And let's be clear. If our government is going to be in the business of marriage licenses, and nothing says it has to be, then we need to do it consistently. Marriage is a profound institution. It uniquely incorporates, the 3 tenets of the first sentence of Idaho's Constitution: property, safety, and happiness. There are 1,300 rights and benefits across our body of laws that flow to married couples. And denying those rights and benefits because you disagree with that union, I think, is the very definition of government overreach. Further, if there is any evidence that either the Obergefell decision or the decision Latta versus Otter in 2014, which actually permitted marriage equality in this state, if either of those decisions undermines Idahoans' ability to freely exercise their faiths, then we need to bring that forward, and we can have that conversation. And for this body, just a final thought here. If a constituent in your district or someone in your church asks you why you voted to stop this today, I think you could tell them 3 things. It was the fiscally responsible thing to do. It was the lawful thing to do. And it was consistent with our constitutional oaths to ensure that every Idahoan has the right to property, the right to happiness, and the right to safety. Thank you, Mr. Speaker.
Thank you, gentlemen. Is further debate on the motion? Gentleman 24.
Thank you, Mr. Speaker. I'd like to debate in favor of the memorial.
Gentleman has the floor.
Thank you. I'd actually like to thank the good lady from 2 for bringing this forward. It's a bold thing to do in this time and culture that we're living in, but it means it's the right thing to do. Whether it's crumpled up and thrown away, whether the wording isn't exact, or whether it's ignored, it is what we need to do as a body and a people. We are a nation that is built on morals and laws, founding documents that mean things. And as we've continued to drift away, I think it's important, just like Roe v. Wade, that we take the time and the courage and make statements to pull ourselves back to the dock of the morals in our founding documents. Our nation's made many mistakes in its history, and it's precisely because of those morals and founding documents that we've righted the ship, if you will. And there's many different facets and facts and realities about this situation, but I do want to discuss a few. We could go hours and hours pointing to Bible verses in Scripture that validates the institution of marriage given by God and how it's between a man and a woman. You could even refer to Jesus when he validates it himself in Matthew, speaking of what the Father has joined together, man and woman become one, let no man separate, right? We won't do that. We could go to the years of social science that has documented how children who grow up in nuclear families with the same mom and dad are happier, healthier, and more successful as life goes on. But we won't dig into that. We could discuss the millennia of cultures and civilizations that up to this point or recently have recognized marriage as one man and one woman. We could even talk about the reality of how quick that decision could have shifted had two of those Supreme Court justices recused themselves as they should have from that case. This nation would look dramatically different from there. We could even discuss the topic that marriage to some people is not a right, it's a privilege. But we're not going to discuss that. We're going to stick, as validating and as compelling as many of those points are, we're going to address the issue of this memorial, which is that this is about the heart of our Constitution and it's about the law, being that the reserved powers of the state and the 10th Amendment essentially still mean something. And according to our state constitution, by the way, marriage is still recognized between a man and a woman. Mr. Speaker, I'd like to read a quote, if you don't mind, to finish this up.
Is there objection to the good gentleman reading a quote? Hearing none, good gentleman.
Thank you, sir. Quoting the dissent, the good lady from 2 touched on a lot of topics, but Chief Justice Roberts is quoted saying, although the policy arguments for extending marriage to same-sex couples may be compelling, the legal arguments for requiring such an extension are not. The fundamental right to marry does not include a right to make a state change its definition of marriage, and a state's decision to maintain the meaning of marriage that has persisted in every culture throughout human history can hardly be called irrational. In short, our Constitution does not enact any one theory of marriage. The people of a state are free to expand marriage to include same-sex marriages or couples, or retain the historic definition. He finishes with this. He says, if you are among the many Americans of whatever sexual orientation who favor expanding same-sex marriages, by all means celebrate that decision. Celebrate the achievement of a desired goal. Celebrate the opportunity for a new expression of commitment to a partner. Celebrate the availability of new benefits. But do not celebrate the Constitution. It had nothing to do with it. So whether today's discussion is just meaningless or pointless, I don't see it that way. I see it as the vital fabric to our society, that being the families, and everyone knows marriage is the linchpin to that. So today is a statement that needs to be made. Thank you.
Further debate on the motion. Gentleman from 11.
Mr. Speaker, thank you. Debate in favor.
Gentleman has the floor to debate in favor of the motion.
Thank you, Mr. Speaker. So I'm debating in favor of the House Joint Memorial. I believe that, yes, while our Supreme Court is the supreme law of the land, they're the ultimate decision in what happens with regard to our laws and upholding or overturning certain laws. They are human. They do make mistakes. I believe that just like the Roe v. Wade decision was bad jurisprudence, I think that Obergefell versus Hodges was also bad jurisprudence. And to that end, I feel like that decision has overrun the 10th Amendment of the U.S. Constitution and has usurped our rights as a state. And to reflect the sentiments made by the good gentleman from 24, the Idaho State Constitution clearly defines marriage as being between one man and one woman. And so, again, I vote in favor of this joint memorial. Thank you.
Very briefly, we talked about Scripture. We don't legislate according to Scripture. There are obviously some guidelines that are deeply rooted in Scripture, but Scripture also tells us that we shouldn't be eating cheeseburgers and shrimp. We don't need to ban that stuff. We are not need to be in perfect alignment with every single thing that's in there. But just as a very high level, my son, one of my sons is gay. He talked to me about this the other week. He was very upset. He's not a very political guy, but he was really concerned about whether he is ever going to be blocked from marrying his long-term boyfriend and being able to live in this state. Not everybody in Idaho understands that this doesn't have legal impact. It's deeply upsetting to some of those folks, and it makes them not want to live here. And these are good people. These are good law-abiding people who are feeling like their legislature doesn't want them here and doesn't want them to be able to, live the full rights that everybody else can. So I hope you'll give this memorial your red light.
Further debate on the motion. Gentleman 17.
Thank you, Mr. Speaker.
Would you like to debate the bill, gentleman?
I would like to debate the bill.
Gentleman has the floor.
Thank you, Mr. Speaker. To me, this isn't about legal arguments, religion, or even the Constitution. What this is about to me is the foundation of the United States of America, which is based on freedom. Freedom to associate with whom you want. Freedom to live with whom you want. Freedom to have the partner who you want. The United States of America, to me, is the greatest country on this earth at this particular time. And it is because of the freedoms that we offer to everybody in our country. The partner you choose is not the government's choice and should never be the government's choice. It's not a nosy neighbor's choice. It's not parents' choice. It's your choice. And that should be respected in every area of our law. This memorial flies in the face of freedom and should be rejected.
Further debate on the motion. Hearing none, would the good lady from 2 care to close?
Thank you, Mr. Speaker. Just to address a few of the comments, there is no cost to this. There is no fiscal note. And if you don't like what this one does, you can always write your own. I would encourage you, just because you like the decision the Supreme Court made, remember, that doesn't mean that the way they made it is correct. And if we don't stand up to this as a sovereign state, who knows, for those on the other side of the aisle politically, you're going to have 4 years of a new administration that might make a lot of Supreme Court decisions or create rights or what have you. We do not want these decisions to be made at the federal level. This is a states' rights. It's local control. I want to address the word reject. So I was trying to find the right word, and the definition of reject is to dismiss as inadequate or inappropriate. And that's what I think this decision is. It's inadequate and it's inappropriate, and it's not the Supreme Court's role to make decisions that our states need to be making. We need to be having, we need to be having these decisions and these conversations in the state, not at the federal level. And with that, I ask for your green light on this resolution.
Thank you, good lady. Debate is closed.
This memorial.
There you go. Debate is closed. Question is to House Joint Memorial 1 pass the House. Since it does not expend money, without objection, there'll be a roll call vote. Good lady, the good lady objects. 3 must rise. There'll be a roll call vote. Question is to House Joint Memorial 1 pass the House. Clerk will unlock the machine. Members will cast their votes. Has every member voted? Does any member wish to change their vote? Clerk will lock machine, record the roll. 46 ayes, 24 nay, majority having voted in favor of House Joint Memorial 1. House Joint Memorial 1 has passed the House. Is a correction to title.
No correction to title.
Hearing none, the title is approved. Bill will be transmitted to the Senate.